graduated.
We have allowed the appeal and set aside the order dated, judgment dated 1/7/2024 passed by the NCLAT on the ground that the appeal itself was defective and ought not to have been entertained.
Right.
Item number 801.
Please, madam.
Not to be deleted.
Please.
Item number 802.
19th August. 19th August.
03.
This will have to go before the chamber judge. If the LRs are not brought on record, how will it come before us?
Their application was already on record.
Very well, it's not been processed yet.
But the
You can't get it before us. What are we going to do with it?
The petitioner has recent defects. They have not cured the defect. They are not.
That doesn't mean that we entertain the IAS for substitution.
Listed before the chamber judge. Then it's not being listed. That is the
Very
problem.
well.
Even
the registry is directed to examine and list before the appropriate court.
very well.
Appropriate registrar, oblique chamber, oblique regular court.
Right.
Item number 804.
We have to give you a longer date, 8th October.
Your Lordships, councils come from Bombay, so right.
8th October, you have a definite date.
Great.
Like
That's fine.
Without a mention, oh, if you want an adjournment, wait till the matter reaches.
Actually, if my lords will see in item 39, the office report states that
We may or may not reach up to that item. If we do reach it and you want an adjournment, please make sure that either you're here or someone represents you.
Your Lordship, if I may please mention item 21.
No adjournment mentions, please. Wait till the matter reaches.
Item number 4.
Item 4, that 4.3 has to be. Along with the counter.
Bail petition, madam.
Only Amul Raj.
Yes, sir. Before that, madam, Lordship, kindly see these, madam. Short notes, madam. There are 4 appeals, madam, in these. Lordship, kindly see, madam. But totally, madam, there are 11 accused persons, madam. One accused was died during the appeal, madam. Then one person became approver. There are then remaining 9 accused persons. Out of it, madam, there is Lordship, kindly see, madam.
Yes.
Page number 1.
Page number 1 of?
Page number 1 of my note, madam.
Note.
Comprehensive note, madam. Everything is there, madam.
Very good. Note. You are happy to.
Sorry, madam. I'm so sorry. Total 9 accused, madam. A1, A2, then A5, 6, 7, 9 acquitted, madam, by the High Court. Then the remaining, madam, the convicted A3, A4, and A8, madam. Out of it, A3 already granted, A4 is granted bail, madam, in 2019. I was appearing in that matter, madam. A8, there is another 11%, that is also granted bail, madam, in 2019, 22/7/2019, madam. I am also saying the parity, madam. So I have undergone
11 persons conviction was confirmed, is it?
3 persons, madam.
3 only.
Only 3 only. Against other 5 people, madam, the state has filed appeal, madam, that is also pending.
That is pending.
Yes, madam. I put the chart, madam, total 9 persons. Others are acquitted except 3, madam. Out of 2, madam, other 2 people already have been 6 years, they have undergone, madam, they have granted bail. Now he has already undergone 11 years, madam.
Your sentence was the same, all of you?
Yes, everything is same, madam. Everything is same, madam. A8 as far as, madam, that is armed fact is there. As far as me is concerned, that is not there, madam. No, Lordship, kindly see the last page, madam. 3rd page, I have given the chart of that. What is the sentence, madam? The chart 2 says, madam, it is A4 and A4 when it was granted. Then the chart 3, madam, sentence undergone, madam. Except 302, other sentence I have already undergone.
request for the state. Parity,
My lords, the other co-accused are being granted bail. My lords may decide on the application. The only request is that the
we're only
main.
asking you whether there is parity between this gentleman and the other two who have been granted
My
bail.
lords, I have to get in.
That is the reason why it's coming up. What do you mean I have to get instructions? If you look at the record, you can tell us whether there's parity or not. You've not looked at the record. You've not looked at the file.
No, my lords, my laptop switched off, my lords. That is the reason.
Without the laptop, you're completely
Apologies, my lords.
unable to work, is it?
You do one thing, you take this file, sit at the back, read it, and we'll take up this matter later. Please, don't go anywhere.
You take it up immediately after the bail matters are over. What,
Please.
item 4 to 12, right? 4 to 12. So after 12, we'll take up your matter, be here.
Please give my file 4.3 to sir.
Item 5.
There's too much unnecessary.
Item 5, he has filed a counter.
Item 5.
Relying on two antecedents, my lords. Yesterday he has filed a counter. He's relying on two antecedents. My lords, I am having the order.
What is the status of the trial though? The counter, you've not said anything.
Your Lordships, in the counter I have mentioned.
What have you said about the trial?
Your Lordships, charges have not been framed. It is at the stage of non-bailable warrants unready. So, Your Lordship, some of the co-accused have not been appearing before the trial court. So, it's at the stage of.
Why does the High Court say the trial is delayed?
Your Lordships may kindly come to para 8 of the impugned judgment.
Para?
8.
The accused who were released on bail
Some
were
are
absent.
co-accused. Some are absconding still. Some of the co-accused are still absconding.
They are not appearing, Your Lordships, when they are called for. Some of
They've
them are
been
on.
granted bail.
Yes, but they are not appearing.
And what steps are you taking?
Your Lordships,
To
still.
get their bail cancelled, you need to take steps if they're not
So,
cooperating
as
with the
far as-
trial. What are you doing then?
So, as far as my instructions, I have not received any instructions as to whether we have taken any steps for
In
cancellation.
your counter also, you say nothing.
Yes, we have not filed
This
an.
counter is filed recently.
Yes. So,
But you at least need to tell us what you're doing about people who have taken bail and are not cooperating thereafter.
Lordships, non-bailable warrants.
Everything we have to advise the state, is it? As to what you should do? What are you doing? Just nodding.
No,
Then,
Your Lordships, non-bailable warrants are going to.
That you have not done, that court has done.
My lords, may I submit? My lords, he is relying on two antecedents, my lords. I am having the
And there are
order
criminal
from the
antecedents.
trial court. He has been acquitted in those crimes.
Or everybody has been granted bail.
Everybody has been granted.
But Your Lordships, he cannot claim parity because he was the one who took out the knife from his possession and stabbed the 3 victims.
But he's in jail for the last 3 years.
3 years he's been
3
in.
years, 24
And there is, Your Lordships, recovery of knife from his.
3 years.
149 is also there. So there is a question of you're saying others are off. He's the only one who's to be picked upon.
Lordships, in the FIR, he has been.
You just file a counter. These counters that you file, as if we are trying the case. We are not concerned with the merits of the matter, whether he's guilty or not guilty.
But
You
Your
need to
Lordships,
tell us what needs to be considered at the stage of bail.
but Your Lordships, his
That you
conduct
don't.
can
You
be-
give us details of the attack. He did this, he did that.
Your
What are
Lordships, his conduct has also to be seen.
For what
all the-
reason? We are deciding his guilt here.
But Your Lordships, he is the one. who
It is a 149 case, we already told you. Where is the question of you're saying that man stands on a different footing, this man stands on a different footing? All other accused are on bail, is it?
all are.
Given the fact that the petitioner has already suffered incarceration, pre-conviction incarceration for over 3 years, and it is not denied that all the co-accused have been granted bail, we find no reason to continue with the incarceration, continue the incarceration of the petitioner at this, the appellant at this stage. We shall accordingly be released on bail in connection with FIR number 6 on terms and conditions to be fixed by the trial court. We shall cooperate Would be cooperate with the client and not take unnecessary adjournments.
Grateful. Item
Five.
six. He's in custody since 25th September. It's 7 years. The issue was whether it's a loan or not. And charge was argued.
Your discharge application is pending.
Charge was argued on 19th February. The court is vacant, not, and they admit that. They admit this fact. I'll just show you lordship is a counter evidence for the moment.
Yes.
The only cases that there is. Kindly just see not counter affidavit, para 10 at internal page 6. Para 10 internal page 6 of the counter affidavit.
Yes.
Thereafter, discharge filed by the petitioner was heard on 19th February, kept for orders. In the meanwhile, presiding officer was transferred till date with court of the special judge is vacant lodged about a year, and it's a 7-year punishment offence. And the issue was even the complainant admits in the original Panchnama that there was some issue of loan that he was returning.
He's not been inside even for a year, Mr. McLaren.
11 months.
Caught red-handed, 25th September
It's not
24.
almost not we are now in August.
So not even a year yet.
But not it's this section 7 offence. And I'll just show you one thing. In
Caught red-handed
I know, Lord, but let me show you something. Let me show you something.
and taking
Yes.
money from the contractor.
My Lord, just see one thing. What does the contractor say?
Contract workers.
The contractor says that it is an issue where there was. We just come to their charge sheet at page. Your charge sheet will begin. P5 would come at 64, please.
There's no officer, is it? Judicial officer has not been appointed.
Sorry?
There's no officer in that court.
But just see, yes. No, judicial
Granting bail at this stage. Pending. Keep it pending for a little while.
But may I just show you what you.
Is it that no officer has been posted? Criminal courts are not normally kept vacant like this.
Special courts not so broad, it's very unusual, it's unusual.
The notification is
If
required.
some additional charge, something should be
Is
done.
No, not because there's a notification required under the special.
Oh, I see.
And the PC Act.
But not, it can't be 5 months, it's 5 months, no, 6 months.
February he limited office. No, but find out why the post is being kept vacant. Counter affidavit has been filed, however, we find therefore that no judicial officer has been appointed. What is the name of the court? Special court?
But I just say no, so not, it's special,
BI is
first additional, I'll tell you about it. But just a minute. First edition, second additional in district judge law.
Second additional district judge,
Districts and
some
session.
special court or something?
anti-corruption.
Just give me a moment, Lord, I'll just.
Special Court Anti-Corruption and CBI.
Special court, anti-corruption and CBI. That there is no judicial officer in the post of so and so since 2025. Then counsel for the state shall assert it as to why
The second edition.
no steps are being
But
taken
I'll give a lordship.
for appointing. No officer till date. File a status report as to why this court is being kept
Give a
vacant.
lordship the exact rank.
We give you a short date, but can't keep these courts vacant. like that.
This is the judge, this is the judge, right, in the bottom.
The name of the court,
Name, Lord, I've given it the notification.
note the
Bottom, I marked it.
this term. Twenty-eighth August,
Lord.
Wait,
28th.
7.
please, your lordship. Your lordship is.
Counter affidavit,
Please,
no counters filed.
Its counsel has been filed.
It's been filed.
When you have filed,
Don't have it.
Because unfortunately, maybe it's not on record, my lord, it has been filed.
We filed it yesterday.
So yesterday I was.
Not filed a counter, 11th August.
My lord, I apologize.
Stamananda.
No matter.
My lords, in item 7, there are 3 matters.
Three
I appear for the state in the first matter. I filed my counter yesterday, so it's not on.
Not come.
but in
The
other
other 2 matters, my lords, the department in its wisdom has not allotted the same to me. If I can get a week's time, I'll get instructions on all.
What have you said in your counter with regard to these people? Have they been identified in the test
So
identification?
number
for
1,
it?
my lords, that the informant has refused TIP. Now he's afraid of
Refused?
whatever, he's refused to participate in the TIP. I've said so in my counter. Number
Informant.
Informant has refused. Yes.
Oh.
So that is number one. We don't know if it's out of fear or whatever it is. From the petitioner in item number 7, recoveries of 500 grams of the stolen silver have been recovered on basis of his confessional statement from 2 other co-accused and the motorcycle. For 7.1 and 7.2, my lords, I still need time for instruction.
Your Lordship, this is a wrong submission. The recovery.
If you need to file a rejoinder, do so. We've received a copy of the counter.
False submission. 330.
We don't have the counter before us, so there's no need for you to argue. We won't retain whatever you say also.
I filed rejoinder.
It is stated that the counter has been filed in
Yesterday in item 7, my lord.
in SLP criminal number 9655 of 2025. However, we do not find the same on record. Registry shall verify and ensure that the same is placed on record by the next date of hearing. Rejoinder, the counter, if any, may be filed by the next date of hearing. Counters may also be filed in the connected matters by the said date. How much time will you require, Mr. Manas?
2 weeks, I'll do every.
3rd September.
I'm grateful.
Item number 8.
Excuse me. 8.
Lord, we have filed a counter.
Counter. You asked for time to file a counter.
Yes, today morning we have filed.
You filed it. Received it. The reason why, in fact, it would have been better if you had not filed it, because we wanted to tell you what we want your counter to address. These young children in these schools,
Right.
we wanted to know whether there's any, what should I say, curriculum prescribed by the state to impart sex education to them.
Please.
Will you do that?
Will
The state government insists on sex education being provided to these young adolescents. Do you or don't you?
We'll have to check it.
That will have to.
And
That is the reason why we entertain this matter, because these youngsters, they don't know what they are doing.
Right.
You don't impart any education, taboo at home.
absolutely.
They don't know anything. Hormones are raging. God knows what happens. This young girl at 14, she's pregnant.
Yes.
What happened thereafter?
He's in custody.
Abortion.
It's a 21
No,
day.
not the boy. What happened to the poor girl?
There was an abortion, and
Abortion.
on that only the FIR was filed. 2.5 months.
Is it an actual case of rape, or is it just two
No,
youngsters
actual case
indulging?
of rape.
It was an actual case.
Yes.
If you don't say it is-
Anyhow, that we'll consider, but we are more concerned. There's another case today again. Youngsters, same issue.
Since 21
We will
days,
file-
23 is in.
We will file a better counter.
File an
Bring
additional,
out
though the legal counsel appearing for the state.
He may be in the meantime.
My lord, in fact, we have
Says that a counter was filed today morning. We are of the opinion that an additional counter affidavit would also be required to enable the state to inform us as to whether sex education is provided as part of the curriculum in the schools within the state of Uttar Pradesh, so that young adolescents are made aware of the hormonal changes that come with puberty and the precautions that are required in connection therewith.
But Malas, in the meantime, even 21/10.
He is anyhow in an observation hall.
I'm saying from 21/10.
We don't know what they've said in the counter. If it is actually a case of forcible
2 years.
sexual intercourse, then it's a different matter.
Almost 2 years, Malas is in custody, and even if it.
We'll give you a short date.
allowed 4 weeks.
4 weeks. Everything.
You also appear for the state, Mr.
No, I'm not preparing.
No longer appearing for the state anymore.
I'm not preparing, but Malas.
That is not change of heart.
No. But if you.
Because earlier you used to oppose such cases like anything.
10th
Malas may see the.
10 September. We'll take it up on 10 September, not too far away.
But consider Malas to bail, consider bail application.
You go through the counter, you've also not seen what they've said.
Next week. Malas.
Rejoinder to the counter already filed, comma, if any, may be filed by the next date of hearing.
Malas may consider this bail application next week, Malas.
Not next week, we'll consider it.
Other aspects, Malas.
No. We'll do the whole thing at one go. Go through the counter, if it's necessary, you file a return.
But my in-laws, there is no recovery from in-laws.
No, at your instance,
You took
16,000.
them to the house of Zaki.
the poetic disclosure, the person who was supplied has been granted interim anticipatory by the Calcutta High Court. Lordship, have the order. 75 and 76 page, Malad.
Who has been granted bail?
75 and 76 page.
What is his name?
Asid Mohammed, the supplier.
This is somebody else.
Yes, he's the supplier, Malad.
He supplied to Zakir Hussain.
Zakir Hussain. And Lordship may have the order. He's been protected. The petitioner led to serve notice about the investigator refrained from taking coercive step against the petitioner. And I'm in custody for last 1 year and 4 months now, Manoj. And similarly, place accused having granted protection, anticipatory protection.
Notice returnable on
So highly great.
10th September. Service shall be effected by all modes including this.
This is also IDPS.
ये तो 6 साल रह चुका है.
I put it.
You've completed 6.
7.
6 plus.
6 years.
Plus 9 months.
6, 9, then it has stopped. That was the
Almost.
certificate 3 months back. Only thing is, there's something against me which I must bring to your Lordship's notice. Lordship should be aware. He was granted a trial started in 2000. It's a 25-year-old matter. In between, it appears that he didn't appear, so he was taken back into custody. So then he was inside. Then he has been inside from 21 till now. He has been continuously inside. Lordships have custody certificate at 145.
When did he jump bail?
Well,
During the pendency of the trial itself?
2003, the Lordship will have by page 144 for a minute.
I see. The conviction came much later.
Yes, Milos, 25 years old matter, Milos.
Oh.
It's a 20.
So after he was caught thereafter.
He was caught and then 20 years he faced trial. So 18 years he faced trial.
Then there is a question of believing that he will.
No, because he has been inside after that.
Now once he comes out, appeal is pending still.
2021 onwards he has been inside. Milos, not now. Milos, just have the custody certificate. Just have that.
6 years, no doubt.
6 years, page
But
7 years.
Is he a person who can be trusted?
Because there is no antecedent.
Yeah.
He's a
During the
person.
trial itself, he
That's why
absconded.
it happened in 20.
Now he's got a conviction hanging over his head.
That's what it
Even
is.
more incentive to vanish.
For 3 years, because if the person could have been caught, he's caught with us. So if he has been caught in because what would have happened is 20 incident, 25 years old. Someday he may not have appeared for because the order sheet is not here. And this also has not come on record because it's only because I saw the custody certificate. I asked the learned counsel who was representing in the trial court. He said he stopped appearing, so he was taken back into custody.
Let us see how his conduct in prison.
Sachin may have some.
Issue notice, returnable on
Grateful. Obliged.
17th September.
Grateful.
Service shall be effected. 11.
Please, Lord.
You are for the response.
Yes, please.
You filed the application. Recall. Application for recall.
We have moved,
We
Your
have
Lordship.
a
We have moved it for recall.
Wait.
In pursuit of the liberty, Your Lordship.
You are the owner. You are the landowner.
I am the petitioner in the original SLP.
Rajendra Singh.
Yes, please. Yes, please.
Yes.
May please, Your Lordship. Your Lordship, the liberty was given to us because this was passed without hearing us. The crucial difference, the order is premised on Harjeet Singh judgment.
Are they
Wherein there
not
was
identically situated though?
Your Lordship, there was a statement
Both
made
of
by
them
the
were
council.
offered plots near
They were
the
identical, but the
plant.
payments were refunded.
Both of them
If
are
Your Lordship-
directed to be given back their money. One took the care and trouble to ask for interest, one did not. But other than the fact that
There is a
he did not
categorical
ask,
statement.
There
There is
are
a categorical statement by the council that nothing more survives in terms of that statement that it was disposed of. That's at page.
you can't
page
keep their
A6.
money and thereafter say you won't pay interest. You're the state instrumentality. We find no
I
ground.
bowed down to that, Your Lordship, but
They
the
call
only thing
the
is the
order.
statement was made by them that nothing survives in the writ, which is annexed at A6. Page 64 order, Your Lordship may have.
As the petitioner in the special leave petition stood, this perhaps an appeal was coming. from my side. So it seems-
Liberty was granted.
Liberty was granted because, but this is.
Right.
Special leave petition. Petitioner in the special leave petition. C number 14854 of 2025 stood identically situated to the appellant in civil appeal number 46, appeal numbers 4614-4615 of 2024, titled Harjeet Singh versus Punjab Urban Planning and Development Authority, and another, except for the fact that there was a slight change in their prayers. That, however, would be a reason to distinguish between them more so when a state instrumentality, such as the Punjab Urban Planning and Development Authority is concerned, is involved and is required to refund the monies unlawfully retained by it, along with interest thereof. The application is accordingly discussed.
So may I just make one submission? Can the payment be made time bound? Because as per the order, they already had to pay and they filed the application.
They filed this application now.
With delay.
They don't pay, file a contempt.
I'm already entitled to 12% now.
Whatever was granted to Harjeet Singh, you'll get the same.
I'm okay.
So the position was dated on the 22nd of September 1995.
But you filed this 227 petition against an order which basically doesn't say anything. That is the reason why the High Court has granted you liberty. But you need to decide what your remedy is. You file an Article 227 petition against innocuous order which appears to be in your favor.
Court says that I am entitled to 15%.
That is not an issue which can be decided in this petition, is it not? That 19th February order, please look at what it said. What it said, disburse the checks.
The court
Give it to my son.
that my objections cannot be decided.
Yeah,
Kindly see February order. For a moment, kindly see the 19th February order.
Yes, which page is it?
Page 75. So I filed an objection saying that the calculation given.
You can't file an objection to this application. What is the application for?
Don't jump to page 75, sir. Please come to page 74. What was your application? What was your case?
Petition for receiving the checks is taken up for passing an order. The petition is only for receiving the checks.
My petition is just above this. Kindly see page 73 onwards. There are 72. I am saying that I am entitled for 15% interest, not 12% interest. There are 8. The calculation which is submitted before the learned executive court was of the issue of 12%. And whereas the learned reference court has given me the interest rate of 15%.
Then you ought to have filed an application for review of this order.
I filed this application, the court dismisses, and I went to the High Court, and High Court said that this order is.
Because your application, if it is not considered in its entirety.
That is my grievance.
So far as this order is concerned, this order only speaks of the disbursal of the check. That's all.
Kindly see page 75 for a moment. Only 2 lines. Not I'll keep.
We can't travel beyond this order.
There is a question mark.
Kindly see.
Now the High Court seems to have given you liberty.
No.
Given you liberty, is it not?
No.
Because it has. Petitioners are, however, left free to work out their remedies in accordance with the law.
Only execution. I filed an execution. Execution is over. The learned executive court has decided the execution in view of the order.
You seem to have clubbed prayers here because the order reads to the effect that you asked for the check to be given to your son. Where did that come from?
That has come because the mother was not there, so therefore she has requested whatever checks are coming because they wanted to give that money. Whatever money was given, the son has taken on behalf of me.
For the court,
Lordship has permitted me that I should file an application before the learned executive.
No. The district judge
for 15% or 12%.
Birbhum will have to.
But that has to be because the contradictory 15% way back in 2001.
You'll have to give me of the record. Leave granted. Perusal of the record. Leave granted to dispose of. Perusal of the record reflects that the petitioners LA execution case. What is the IA number? It's not IA, is it?
Not execution number, not a execution.
In that you filed an application. There is no application number also.
So there is no. It's dated 30th of November 2024.
Where is the date?
I stated in the list of date because the order was passed on the same day I filed an application and it was considered on 19th of February 2025.
Petitioners raised an issue in their pending arising out of LA number 40 of 1997 that they, comma, being the decree holders, comma, at the rate of 15% in bracket simple interest per annum, but the calculation is to 12%. But the payment was sought to be made by the authorities. The interest at the rate of 12% annum. The executing court of the learned district judge Bedvam Suri passed order dated 19/2/2025 without taking into consideration this aspect. Agreed thereby, the petitioners approached the High Court by way of CO number 1247 of 2025 and Article 227 of the Constitution, but the High Court held that they could not have any grievance with the aforestated order dated 19/2/2025 inasmuch as it only directed disbursal of the payments by way of checks. The High Court, however, left it open, left the petitioners free to work out their remedies in accordance with law. We are not inclined to entertain this special leave petition at this stage, but are conscious of the fact that the executing court of the learned district judge Birham failed to consider the issue of interest raised by the petitioners in the execution case. We therefore leave it open to the petitioners to seek review of the aforestated order dated 19/23. And any such review petition, comma, if and when filed, comma, shall be considered on its own merits, uninfluenced by the impugned order dated 9/6/2025 passed by the High Court and the disposal. Only that. We gave you liberty to file a review petition.
And give you license.
Item number 4.
Yes.
Item 4. Yes. Use argument.
Yes.
Let us see what he has to say.
My lords, so parity is the same, my lords. A3, A4 and A8.
Parity?
Parity is the same, my lords. A3, A4 and A8 were convicted, my lords.
Or
A4,
same sentence?
Same sentence, identical sentences. A4 and A8 were granted bail on 22/07/2019.
What is the period of incarceration that he has actually suffered through?
Nearly 11 years, my lords.
That's not very clear because if you look at the...
It's there in the bail application.
You get page number 9.
Your custody
Page number 9.
9.
Relevant is column number 29.
10 years, 9 months, 9 days.
So, did you suffer any incarceration prior to the conviction?
That is there.
There's no mention here.
There is there.
Yes.
Set-off period is 961 days.
Period of remand set.
Yes, sir.
960.
3 years.
And then you went into prison on 24/3/2014. Then again, December 2014, you were granted bail.
Yes.
And then you went back in
17.
That was
in 2017. 7 years, 8 years here.
Yes, sir.
And then 961 days as a pre-trial.
And today 11 years.
10 years now.
Others were granted when they after 7 years.
He's A3, is it?
A3, yes, ma'am.
We find from the record that the co-convicts of the appellant, namely A4 and
A8.
A8.
4 and A8.
Kumar alias Gopal and Ella Varasan alias Pandian alias Vallavan. Within brackets A4 and A8. इनके नाम के बाद A4 and A8, comma, to stand on par with him were already granted bail by this court. Both of them were granted bail by in that view of the matter, on the principle of parity, the appellant Amul Raj alias Selvan is also entitled to grant of bail. We shall accordingly be released in connection with
Amul Raj A3 million.
A3. Amul Raj is A3. On terms and conditions to be fixed by the trial.
Yes, discussed.
Yes.
Great.
One.
One.
Hello.
Where is the high school record? Where is the primary school record?
My lord, respondent number 1 has not filed the counter record.
No, state.
Counter is filed by R1.
My lord,
State has not filed.
My lord, we are appealing for state.
But where are these documents though? Neither you nor respondent number 1 seems to have thought it appropriate to file them. The whole case turns upon your date of birth as reflected in either your high school record or your primary school record, both of which are not placed before us. You'll be getting it by the afternoon.
No.
Then, for what reason do you want to pass it?
My lord, the main counsel is held up in court number.
He's going to fetch it out of thin air. He'll be getting it out of thin air or something. We don't have those papers. Without those papers, the case can't go on.
My lord, I have no idea.
Is it a matriculation certificate? That also we don't know. Is it an admission in the high school?
It's a 10th certificate, my lord.
It's a matriculation.
Matriculation.
That's not how the order reads also.
My lord, kindly permit to file rejoinder.
File a rejoinder to R1's count.
My lord, we will also file within 2 weeks.
If they don't file it, you at least file what this record is.
My lord, we will.
When comes appearing for the state, seeks some time to file a counter affidavit. Rejoinder, comma, if any, to the counter affidavit filed by responding number 1 may also be filed by the next date of appeal. So, you pehले omit which will be done in that effect by the next date. The primary school record as well as the high school record, which contain the contradictory, don't say conflict, which contain different dates of birth of respondent number 1 shall also be placed on, shall also be filed. List on 10th September.
My lord, our presence is marked, my lord, because we are unable to give in online.
Very. Not the case.
We will give, my.
Give it in.
I do.
Please, my lord. In this case, my lord, the High Court has quashed.
My lord, in this matter, my lord, in this matter, mediation is going on in the lower court.
Mediation is going on. Where?
In the lower court, my lord. There are 2 other matters, my lord.
You have no instruction.
My lord, the order is here, my lord. We have brought the order also. The matter was listed for extension of time, my lord. Page 4, paragraph 3 and 4 will show, my lord. On there asking, this was referred to mediation, my lord. Paragraph 3 and 4, my lord. And the next page it is in Hindi, my lord. Last order is that this is sent to the court. They were asked to appear for mediation, and then it was sent to the court for extension of time, my lord. On 8th of this month, it was listed for extension, my lord. Court was not there, my lord. It has been transferred to some other court.
Where do you find 8th of this month, the date?
My lord, the 8th of this month order is not there because the court was not sitting that day. And we were informed that this has been transferred to some other court.
So there are three connected matters, my lord. We had filed two, 138.
You have no instructions, but there seems to be some order.
That is some other matter which is going in between the.
This is connected to this one, you know.
7 of the impuned order. The entire proceedings have been watched, so how can?
In one case, there are three cases,
Three
similar
cases.
cases. So he's saying,
The same
he's saying
138.
that litigation is going on.
Those are the matters that
If
he
they
is
want-
setting against my client.
What is your complaint number?
Because my complaint number was 14276 of 22, criminal case number 204 of 22.
What about this 2608?
In fact, my lord, I
It is a 138 matter and he has filed against my
But
client.
anyhow, let the mediation go on. If you settle,
Fix a date, my lord, because otherwise.
fix a date. We are informed that the parties are attempting settlement through mediation before the trial court, and the proceedings in that regard are still ongoing. This from 24th September. ये नहीं आएगा ना वेडनेसडे नहीं आएगा आजकल सब आ रहे हैं
Criminal matters.
आज नहीं
I'm sorry.
online.
Item number 3.
The respondent has not entered appearance.
services complete.
My leave to appeal was dismissed. The ground that I have not.
You have no documents to show.
That's right, but unfortunately, what is overlooked is 139 and 118, where there is an initial presumption in my favor. In fact, the trial court decides to.
No, but how is it possible to believe that you have no document at all with
No, I have. I placed
purchase of practice?
That's right. If I may only say, I placed it before the High Court.
No invoices.
Right.
No invoices.
My 391 was dismissed when I placed that document on record to show that I have these invoices.
Why? So you filed it?
Yes, before the High Court. Now, unfortunately, today.
No, but why is it that you did not produce it before the trial?
In fact, the consistent view of this court is that I just have to prove the check. The presumption kicks in. 139 presumes that I have the check for discharge of legal back. A suggestion, Madam. That may require a detailed hearing before the appellate court. I'm only requesting if your lordships can consider remanding the matter to the appellate court.
When was the service effective?
Yes.
When? There's no mention of
23rd of April 2025.
It was
notice
then.
being issued, and thereafter, Madam, the status, he filed an affidavit.
We'll give you another date. Let us see if they come home. Office report indicates, office report dated 11/8/2025 indicates that the respondent has been served. Respondent number 1 has been served but has not chosen to appearance. Only one respondent has been served, not chosen to enter appearance. There is, however, no indication as to when the actual service was effected. On the matter to enable the respondent to put in his appearance if it so chooses. Next on 10th September.
Great.
Because as per the Himachal Land Revenue Act, section 163 minutes, it provides that in case of adverse possession and title.
Concurrent finding.
Yes, exactly. Please consider
And
this
you also, you say that the land came to you from your ancestors on one hand and then you claim adverse possession on the other. So you're not certain as to how it came to you.
Let me say this, Malak. All these proceedings went when there were restrictions during the COVID period.
Just all courts, every forum has held against you.
It's kindly considered they had no jurisdiction as per
Where is it?
Because once
You're not even certain about your own stand. You say it came to you from your ancestors on one hand, you say adverse possession on the other. There's no mention of how it actually came to you, how long you've been in possession, nothing.
not able to procure the documents for the simple reason.
Sorry, Council, with these kind of findings, we
During
can't.
the COVID restrictions, Malak. Please
We
have
can't
the dates,
really
Malak.
help you.
Because it all started from 6 to 2020 minutes, and the restrictions started thereafter minutes.
Your appeal was dismissed in 22. The financial commissioner dismissed it in December 20.
In a similar matter, madam, they have
Single judge in October 24, division bench in January.
In a similar matter, madam, they have remanded the matter back for.
Well, there needs to be something at least. You have nothing at all.
It was during the restriction period.
Sorry, Counsel. We find no good ground and reason to interfere with the interim judgment asked by the High Court, especially questions of under dismissal. Yes.
But this was a case of conversion of a scheme. And it happens like this. That
you do not deliver those 8 buildings which are meant for the.
So their buildings.
That purpose. So now you want to take advantage of your own delay in constructing those 8 buildings.
Completely wrong.
That is how the High Court.
High Court is High Court was prejudiced rather than not the law. The Lordship will just now note 2 or 3 things.
Yes.
And just note 1. The scheme came in 2008. Lordship may note that.
1611 2000.
21808 is the scheme under which, Lord, I get 3 FAR for my private sale component and 1 FAR which I have to build, Lord, for free rental housing and give it to the government. So total is 34 buildings, 26 will be free sale, Lord. That is my component, and 8, Lord, G plus 17 will be, Lord, given free of cost under the rental housing scheme. Now I started, Lord, in right earnest, and the problem arose on 7/8/14. To build, Lord, 34 buildings takes a number of years. On 7/8/14, Lord, they revoked the scheme, which is at page 91 at 104. In the revocation, they said, Lord, that those who have done it in the past can still carry on. That is, Lord, like any other saving clause under any other law. Now, to carry on was, Lord, in 2014, and then came, Lord, what is called the UDCPR regulation. While I was carrying on.
You completed your 34 buildings when? Sorry, your 26 buildings.
I still don't have the OC.
Your 26 buildings, when did you complete?
No, I don't have the OC. They are not technically complete.
When did you complete them?
Lord, if I don't have the OC, they are not completed, Lord. Nobody is living
construction
there.
You've completed.
But nobody is living. Yes,
nobody might be living there, but you completed the construction.
Yes.
When?
Lord, the date is not here, but you might.
That is very relevant.
For 4 or 5 years back, or 4 years back, or 3 years back.
And
please proceed with that, please. Now came UDCPR, Lord, in the year 2020. Now your Lordship sees UDCPR, page 111 and 138. Am I entitled to switch over or not switch over? It's a matter of a scheme, Lord. It's not a matter with respect, Lord, for the High Court to say that I'm going to give you a project or not give you a project. Kindly turn, Lord, straight to 138 and then 139.
138.
138.
Yes.
Your Lordship will find savings, Lord. This is the new regulation.
Yes.
Notwithstanding anything in this regulation, any development permission granted or development proposal from the action is taken under the erstwhile regulation, that is the earlier one, shall be valid and continue unless otherwise specified. So I could continue under the rental scheme. Now turn to the next page, the third proviso at 139. Provided further, what was it?
Yes.
139 now. This is not an exception to that saving. Provided further, it will be permissible for the owner either to continue to develop the project as approved under the erstwhile scheme in toto, which is not their rental, and for that limited purpose, that regulation will continue in force. So now this was either, now the or is at page 140. Now turn to B. Just above B, you also will find or,
yes,
the last line of that para, or apply,
yes,
apply for grant of revised permission under the new regulation if the project is ongoing and OC has not been granted. This is the only consideration I have to show. So, my lord, project is ongoing, OC I don't have, nobody can occupy those 20.
If OC is not there, then also it was permissible.
Sorry, bro?
If OC was not there, then also it was permissible from. for switching over from scheme A to scheme B.
If I got the OC, my lord, then it is not permissible to switch. It's that way. So idea is if you are ongoing and yet to complete, you are entitled to switch.
Please read it again.
I'll read it again. Or apply for revised permission under this regulation. New means this. If my project, which started earlier, is ongoing and OC is not granted. So two conditions have to be fulfilled, my lord. Project should be ongoing and you should not have had the OC. So it is meant, my lord, to curtail those people who pocket the OC and then say, now I am going to change. You can't change unless it is ongoing. Now it is admitted that I fulfill both.
What is the additional benefit you get now under this?
Sorry, bro.
What is the benefit that
I'll tell you.
I get now?
No, but there is a twist. There is a final twist, and I'll tell you why. Originally, my lord, people went in that rental housing scheme because FAR, my lord, was not 3, was 2. So to get 3, you had to, my lord, build free. That's how you got 3, and one FSCI, my lord, build free and give it. So the builders thought it is better to get 3, give 1, my lord, for free, and my lord, make some profit. So that's how I started. Then came the new scheme. In the new scheme, my lord, instead of giving free to the government of India, I told the government of Maharashtra, they said instead of free, you build, my lord, affordable housing. Those 8 buildings, instead of giving free to the government, will be called affordable housing of about 200 square foot each. And, my lord, the price is pegged, and what is pegged is the income level for the EWS to get it. So if somebody earns 5,000 rupees a month, my lord, he'll be eligible to get it. So the value of that flat will be 5 lakhs or 10 lakhs because it's very minimal. So between the old scheme and the new scheme, obviously I will make something more into the new scheme. Number 1. Now number 2, the final circle, my lord. Today, the FAR, apart from these schemes, have now become 3.
Under the old scheme, did you have any timelines?
No, my lord. No.
None.
That's why they say project is ongoing. No timeline. No timeline. And now, under this scheme, I have to pay some premium to the government to get TDR, etc., for which I am not bothering you also. Now, just see what the High Court said. This is the only thing. The High Court seemed to be prejudiced by the fact that you have completed your own buildings but not completed that, the structure is ready for them. I will complete, I am going to give you an undertaking that either I have to complete those 8 plots. Either they will go below free or they will go for affordable. Where's the question? I am not going to pocket those 8 buildings. Your Lordship can record my statement. If I lose before your Lordship, let's put it this way. If I was to lose before your Lordship, then I have to give them 8 buildings free. The structure of which is ready, I'll complete and give. If I was to succeed before your Lordship, then the 8 are not given free, but are given to EWS, that's all. But I have to complete 8. This is the error. Now see, my lord, turn to page 22 bottom. Complete error by the High Court. 22 bottom, my lord. My lord, turn to 22 bottom.
Yes.
Last line. Merely because the actual construction is ongoing. My lord said that.
Yes.
That's the requirement. And I don't have the OC. He do not make us believe it is ongoing. What does that mean? It's either ongoing or not ongoing. It has nothing to do with the fact that I will not build something first and something later. And that's why, my lord, the High Court is feeling as if the High Court is giving me something as gratia. And therefore, we will not permit the petitioner to turn around, 4th line of page 23, and take benefit. The law gives me the benefit. So I am entitled to put my affairs in order, my lord, and then make an attempt to wriggle out. What do you mean wriggle out? The scheme says you can change from that scheme to the new scheme. And therefore, Lord, I am ousted for nothing. And now, Lord, I show you, Lord, something very, very important. The Lordship may see one more thing. Turn to 161. This is clinching. I should have shown it earlier. 161. 161. This is the authority to whom I have to give the free flats. This is MMRDA. My Lord will see on the top. Number MMRDA. That's the planning authority. Dated 31st May 21 after the new scheme came. Proposed rental housing scheme falling within jurisdiction of Pura Bhayandar Municipal Corporation by Neil Kamal, no objection. Please refer to the letter where you have requested MMRDA to cancel the rental housing scheme and grant NOC so as to grant revised building permission as per so and so of the new scheme of the next scheme. Next, second paragraph. in view of the urban department clarification, the scheme can be converted from rental to UDPCR as the applicant has not executed in the agreement. MMRD has therefore no objection for converting rental to UDPCR. What more is required? They are the authority, my lord, to whom it has to be given. They are also agreeable. I read the stipulation, my lord, under the law.
This is what the High Court. This is one in the date. Is it clean? Constructed these 8 buildings also.
Yes, it's ready. My lord, I please record my undertaking. I will give, my lord, finished 8 buildings to MMRDA.
You've not finished the interior.
I will do it. I am recording. My lord, 8 buildings of G plus 37. It's not hanky-panky, my lord, I am going to run away. Matter of some substance. It's what I submit your lordship, my lord, look at it.
Yes.
There is no hanky-panky, my lord. Suppose I had not built anything.
MMRDA is in your favor.
Yes, my lord. And they are the authority to whom I have to give those free.
It is the municipal corporation which is
I
against.
think municipal corporation here has no role, my lord. I applied to the local municipal corporation only for revalidating the plan from rental to EWS. And the size is the same. You know, the size of the flat is the same. I don't have to change the building at all. Whether it was free or whether it is EWS, size is the same. So there is no reason, Miller, to frown upon me to say, oh, I am going to take some undue benefit or take somebody for the ride. There is no complainant involved. It's not a flat bar kind of a situation. But yes,
I don't understand how the building has become illegal.
No, it's not illegal.
Now also
it won't be illegal.
No, this para, this.
Last para.
No, it can't be illegal.
No, it can't be.
I have to give those 18. And then it goes free without or it goes to EWS. There's no illegality involved. It's not
legality according to the High Court is your delay.
But my lord, with great
This is the
respect.
obligation which was there.
So then, no, we are not talking about this.
She's there.
No, please understand. If 26 buildings have to be built and 8 buildings of 37 floors each have to be given free, look, I have to earn something to build them. I don't have those kind of pockets that I'll first build 8, that is some 500 floors. 37 floors multiplied by 8 is not 300 floors. To build that, I have to sell. Also, that's how it happens.
We'll issue notice, let them come.
May I request for a short notice because I have a proposal which I'm not making just now, which I will take when they come. So give me
Notice, returnable law.
after 2 weeks or so.
9 September. So we shall be effective.
Like the number 16.
Please, sir.
The office report says you filed it, but you don't have anything.
I have 5 minutes, probably they have replaced it.
Where are the IAs? They did not come. Yesterday also, even IAs are there. In the office report, they mentioned the IAs, but no IAs. We'll pass it over, Mr. Gupta. You filed translated copies? You filed Telugu as well as the translation.
I'm asking to.
We'll take it up at 2 there.
2 o'clock.
This there.
Number 17.
2 o'clock.
Is there?
No, it's e-copies there.
Copies.
Also, sir, directed me to take instruction.
Yes.
Whether the respondent is willing for mediation. In fact,
Yes.
also I verified what is his fact matter in the matter. My lord, mediation had taken place.
If he is not willing, he is not willing. We are not going
My lord, sir,
hold
some
it
aspects,
against.
my lord, if he is willing for mediation, to show his bona fides, let him deposit some amount and go for mediation. Let it not be a dilatory tactic. Because this is a check bounce case of 2017.
You are for R2.
I'm for the private respondent.
R2
is the state.
I'm the state.
Let him demonstrate his bona fides. I'm willing.
The other side is a lady.
Yes, a lady, my lord. She's running a petrol pump. She's running petrol pump. I
You
had
want her to deposit. Who is this? Let him.
my lords, her, my lords. I'm sorry, my lords. So she's a proprietor of a petrol pump. I constructed the petrol pump. It was under IOCL guidelines.
That is what you will settle at your mediation, is it not?
Not let them pay some amount and go for mediation. Otherwise, it will be only a dilatory tactic. He's 2017.
There is a way she is not in a position, but
Hey, 3 checks she gave, 17 lakh each.
4 checks, my lords. 4 checks of 17.
4 is it?
Yes, 4 checks. 4 checks, my lords. And
3 checks of 17 lakh, 1 of 1730.
This was the stage of examination, my lords in chief. Process had been completed. After that, they have come before the High Court for seeking transfer. This is this conduct.
You will seek instructions if she is in a position to pay. And then you
We'll take it up in the afternoon.
week or maybe
Afternoon. You just find out whether she's willing to pay. If she's willing to pay at least 1 check amount.
I agree, my lords.
I request a
17 lakh. He's constructed the whole thing for you. You gave him the check.
The real story in your is they received a widow. The other fellow is running the business in a name. So
I see. He's doing the business.
Yeah, because the
Brother-
construction is undisputed, my lords. Construction is
So the
undisputed.
real story.
No, but you got the dealership in her name so that you can run it.
No, he's a civil contractor, my
Because
lords.
they have that reservation
My
of
lords,
him.
that's the impression she is giving, my
Now
lords.
the real life situation, that's your lordship.
Need
I will
that.
know.
Where to?
He's a civil contractor. The respondent,
Let's explore all the possibilities.
This is a very possible.
yes, my lords. The respondent is civil
You are
contractor.
behind the scenes. She gets the retail outlet dealership in her name,
Yeah.
and you are there.
Now we
You are
know.
running the show. This is
That could have been a situation right then. Right now,
Oil companies have reservation in the name of women, and this is how it is abused.
she is running the petrol pump. The petitioner is civil contractor.
You are now in charge of the petrol pump.
Yes,
He's
yes.
there. He's
How can he be charged if he has lodged a criminal case against me, my lords? He's lodged a criminal case, a case of 420 that there's a defense plea has been advanced that I have taken the checks.
This petrol pump is still running.
Still running, my lords, under her control. And today she comes up with the defense plea that cannot be converted in this proceeding.
Then you just go for mediation if you're interested.
Let them pay some amount and go.
Whatever it is, you settle it at that
My lords,
negotiating.
saying that this is only a dilatory tactic because it was attempted in the
If
High
you
Court.
don't want it, say so.
My lords, my lords, he is not capable.
Then we'll
Genuinely try and consult and all that with all the.
Because the High Court also fallen from.
pass over them.
1 week.
Why do you need 1 week? Do you need to think it over?
No, because the.
You're related in any event.
The advocate who is in touch.
If she is not willing to pay, my lords, what outcome will the mediation bring, my lords? If she is not willing to pay today at all.
He is your sister's husband, is it?
Yeah, they're related.
Related, no.
The brother-in-law.
Brother-in-law, sister-in-law.
Brother-in-law can be both ways.
Even that is,
Sister-in-law.
even he isn't clear. I spoke to me.
Husband was actually running the business. After her passing away and all that, her name is being taken.
No. That is wrong. That is incorrect, my lords.
Being a widow, she is entitled to the.
No, that is incorrect. She asked.
You know.
Lady was granted the IOCL RO.
IOCL has.
It's been granted in her name.
Yes, ma'am.
Not in the name of the.
Because she's entitled, because it is going to be a widow's quota. That is how it goes.
She uses the services of the respondent and then after that runs away from a
Number
liability.
2 states that his client is willing to attempt mediation, attempt settlement of the dispute through mediation, but would insist on payment being made in proof of bonafides by the petitioner. When counsel for the petitioner seeks some time to get instructions in that regard. Based on next Tuesday. Next Tuesday is 19th. Yes,
What is the date?
19th of.
Apply.
18, I'm just seeking the passing. I'm led by Mr. Nadkarni.
Passover.
Can I start?
Passover.
Yes.
It's a Passover.
Adjournment
Mediation is ongoing. Let us.
Right.
One counsel for the petitioner filed a letter seeking an adjournment on the ground that mediation is still ongoing between the parties.
14 and on bill.
14.
See,
Miscellaneous. 23rd Sep.
Wait,
Yes.
the petition for lordship filed a suit, madam, OS 171 of 2015. The petition for he filed a suit OS 171 of 2015 for declaration of title and other ancillary things. The trial of the suit was settled after the trial, the recording of evidence was concluded. The fifth defendant filed an IA with a prayer to send the Xerox copy of a written statement in a particular suit for comparison with the signatures on the Xerox copies of the written statements in two other suits of the same time. Now, the trial court may not dismiss the IA, saying that the signature on a photostat cannot be, copy cannot be permitted, and at any rate there was no issue on that at all, and there was no admitted. One more thing, the person, the signatory that is defendant in the suit, he himself filed a suit that is OS number 219 of 1994 during his lifetime for declaring that the signature on the written statement in that earlier suit, 74 was not his signature. For reasons best known to him, he did not dismiss the suit was dismissed. Now, this gentleman, fifth respondent, who is the grandson of the deceased person, he says that his signature be compared. Now, the High Court dismissed the High Court says that it has to be compared and
the notice?
No, notice is already issued.
The notice is issued.
Notice is already coming for and the before the honorable court Miller, they gave an undertaking not to proceed with the matter. And
what is appearing against you?
I'm appearing.
Service is complete.
I'm appearing on behalf of
Varun Punia. Varun Punia.
My lords, I am appearing on behalf of respondents.
Yes. Are you ready?
My lords, with due respect, my lords, that the prayer was not with respect to sending of the true copies of the documents, my lords. At page 18 of the order, my lord, that was clarified by the court. My petition was to
page 18.
It's page 18, my lords.
Yes.
Statements in OS number 202 and 203 of 1974 from the, their contention was that, my lords.
Where are you reading?
It's page number 18, my lords.
Yes, statements at the top.
Statements in OS number.
A sentence from the beginning,
yes,
not from the middle of the sentence.
It starts at para number 21, 17. Yes. The trial court also dismissed the said application on the ground that the files are not available and the photostat copies of the written statements, which are certified copies obtained from the court record, and therefore photostat copies of the documents are not fit for comparison. That too, they pertain to nearly 50-year-old documents. It is relevant to note that the defendants have obtained certified copies of the aforesaid documents, that is Exhibit B7, written statements, and in OS number 741 of 1975 and Exhibit B20 and B21, written statements in OS number 202 and 203 of 1974 from the court of the district municipal. Thus, the said original document must be available in the said court. My submission, my lords, I have made an application under 45 of Evidence Act to summon the documents, original documents from the concerned court, and that was also allowed. That petition was also allowed, my lords. That petition was also allowed.
This
original documents were summoned by the
Awaz bin Musallam is your grandfather.
He is the father of the plaintiff and the defendant number 1, my lords.
Very good. Now, the other side, you are claiming under the judgment in OS 741 of 1974.
That is 74. The number is 74.
74, not 741.
74. I am not claiming under that.
You are not claiming under that judgment. That judgment is now what is sought to be attacked.
not.
Neither I am attacking.
No,
nor he is
he is attacking that judgment, is it not?
It's not.
Written statement filed in that written statement filed by Awad bin Azad in that suit is not genuine. He doesn't challenge the decree as such. Not a suit is filed for declaration of the decree in that suit as
No, but the number is noted as 741 of 1970.
Sorry, 74. That object was
That is 741, my lords. 741 of 1975.
741.
Yes.
Even in the judgment, it is referred to as 741.
Yes, that's correct.
Now, you are saying that the written statement supposedly filed by Awaz bin Musallam in OS 741 of 1975 is a fake document, that the signature in that written statement is not his.
No, it's not that, Your Honor. Subsequent to that, I filed a suit by OS number 219 of 1994.
You did not file, he filed. Awaz bin Musallam
Yes,
filed
my father filed, contending that
is he a father? He's a grandfather. Grandfather. You're not even aware of the relationship. He's supposed to be your grandfather, not your father. Grandfather of defendant number 5.
Says, my lords, I'm sorry, it's grandfather. Here, my lords, he filed a suit while OS number 219 of 1994.
Which he got dismissed as not pressed.
It's not that, Your Honor. My contention in the written statement is not that. That suit was dismissed for reported as not pressed subsequent to death of my grandfather.
Whatever it is, you got it dismissed as not pressed.
But the fact remains that, my lord,
when
the
did
fact
he
remains
die?
that. No.
When did he die? Please answer the question.
He died in the year 1994, my lords.
Do we have the date of death of this Awaz bin Musallam?
Yes, ma'am. That is the reason why I filed additional
Where
documents,
is it?
my lords. Additional documents petition I have filed that is pending, my lords.
That's pending. Not before us today.
It's there, my lord. It's there.
You don't have an additional documents. Is
I have filed an additional documents petition, my lord.
No, there is one. 129142.
Only counter affidavit is there.
One counter affidavit and a petition to receive additional documents.
It's a 2025 application.
It's
List में दिखा रहे.
अच्छे इसमें पेपर कुछ नहीं है.
Paper document 25
Like
kilo.
the statement is also in this paper.
These are 24 only. No 25 applications. 25 applications. Have you received a copy of this IA? This IA for additional documents is not placed before us.
I don't think so. It is not served as
IA number 129142 of 1920.
It's not available either in the court record or with the other side. Please furnish a copy to the other side also. Registry is directed to verify and put up the file pertaining to IA number 129142 of 2025, which is shown in the cost list. It is not available in the record.
Further proceedings will
A copy thereof shall also be furnished to the Grand Counsel for the petitioner. Based on 16th September. In the meanwhile, operation of the
my submission, I am opposing that.
5/8/2024 shall remain state. There's no point in
my lord, my only submission, my lord.
First, you'll have to convince us that you are at liberty to follow up what your grandfather started and then gave up on his own.
That's not the defense, my lord. That's not the defense.
We don't know when he died, so we'll have to consider that.
That's not the case, my lord. No, when the matter
nothing is going to be lost if the
last submission, my lord.
Proceedings don't go on right.
My lords, if the proceedings under 45 Evidence Act are stayed, the suit is posted for arguments, my lords. I would be denied my defense. If the suit proceedings are stayed, that is a different, my lords. If the order of the High Court is stayed, my lords.
Stay of the operations. Anyway, you will inform the court that the matter is pending here. Why will you go on to the stage?
No, but the matter is identified, my lords. They don't adjourn the matter. Let the proceedings be stayed, my lords.
Not this. Not this.
131, yes. 31.
My lords,
there in the file.
Yes.
My lords, if the matter is posted for arguments, my lords.
In this question.
When the suit is posted for arguments, my lords, The suit is posted for arguments, my lord. I would be denied my defense, my lord.
You may bring it to the notice of the court that the matter is pending here. Why will the court insist on hearing arguments when we are seized of the matter?
My lord, that may not be, my lord, because they have also represented
Your
with respect.
persuasive skills there instead of on us.
No, they have also represented with respect to pending.
Counsel, we've already passed the order. Nothing more.
My lord, let them be proceedings may be stayed, my lord.
Next matter.
Copy of the SANJAY is there in each factor. E-copy is there.
Of this also.
Confusion.
Yes.
My learned friend says that the instructing advocate here says we are taking an accommodation. I was not told. I don't want to put him in difficulty. It's only fair. But if he wants to go on,
no letter given to us.
He called me blood and said the council is in difficulty.
No.
Oh, the other side said they are in difficulty.
My instructing advocate would have said that. In fact, I had a late night conference. I didn't know that, but I didn't want to. It's fair.
You want another date?
Next week, because
whenever it's convenient. But I don't want him to. That he's kind of
very embarrassing to me also.
No,
It's on 19.
Review.
19.
Review.
Lords, there's a letter in item number 20.
No,
Lords, the interim order may be extended because.
Your lordship may extend interim arrangement. There is an interim arrangement not to raise bills.
Whatever the interim order is.
Yes, my lord.
And counsel for the petitioner sits in adjournment.
Let the interim arrangement shall be extended, my lord.
On the ground that you need to file a rejoinder.
I will have to.
But
they filed a counter yesterday night.
Has been filed only yesterday, and he requires time to file a rejoinder there based on 23rd September. Earlier interim order dated 15/4/2025 shall stand extended to me.
Obliged.
Interim arrangement, my lord.
Yes, extended.
22.
23.
Yes, ma'am, I explained. Can I hand over a list of dates?
Yes.
This is against actual order more.
Who's opposing you, Ms. Mehta?
Who's opposing us? Who's opposing us?
Mr. Snehashish Mukherjee.
Yes, sir. Company has been appearing, that is what I'm informed.
Mr. Mukherjee.
The AOR is Mr. Snehashish Mukherjee. One? Yeah, you can make a beginning.
Yes, so I'll hand over.
Here also.
And I've framed the three substantial questions of law. The Lordship knows under 125, I have to, my Lord, point out what are the substantial questions of law.
Yeah.
So, Lord, I frame the questions and then put the Lordship's, my Lord, to the list of dates first.
Naam Snehashish. Yes.
The three questions which I framed are this, Lord. Whether R1 was entitled to the benefit of force majeure clause without invocation and without adherence to the procedure prescribed therein. This is an admitted position, Lord. They didn't invoke the force majeure clause prior to, which is the condition precedent, nor did they plead it before the commission. Whether KERC and APTEL erred in giving the benefit of force majeure clause to R1 in the absence of any pleadings to that effect. And third, whether KERC and APTEL have the power to rewrite, modify the PPAs entered into between the applicant and R1. Now, my Lord, the list of dates, my Lord. The first date is, my Lord, 12. CEC, that is myself, my Lord, appellant and R1 entered into a PPA for purchase of power from solar project floated by R1 at a tariff of 8.49 per kilowatt per hour. The PPA was approved by KERC and KERC suggested certain modifications that were implemented by way of supply of PPA. Lord, the location was changed. There are certain clauses which are relevant.
What's the supplementary PPA, is it?
Supplementary is, Lord, there.
No, you said supply PPA. So
sorry?
You said supply PPA. So we are presuming that's a supplementary PPA.
No, there
or you have a supply PPA and what?
The respondent, Lord, is to supply solar power. I take the solar power.
Yes.
PPA is executed. then there was some delay, they sought extension, so we executed a supplementary.
Some modifications were also.
Correct, my lord. So we allowed, my lord, that extending the dates, my lord.
We wanted to know whether there is something called a supply PPA or is it supposed to be a supplementary PPA?
Supplement. My lord, I'm so sorry, my lord, I didn't realize that I used abbreviation on short version. My fault, my lord.
Very well.
So, my lord, some of these clauses I would like to read, my lord, or I could run through the list of dates, then take your lordship.
Whatever, however you wish to do it.
Very well, my lord.
If there's more clarity, if you take us to those pages while you're going through the list.
Yes, my lord. So let me take your lordship through the various clauses, my lord.
Yes.
Now, my lord, condition precedent, your lordship will find is clause. My lord, the additional documents we filed, my lord, which would be PDF 621. Lord, if your lordship has the additional documents, because the PPA and the supplement agreement, Lord, we filed therein. I don't know, Lord.
Is there an IA number on the additional documents?
Compilation.
It's a compilation of documents.
Compilation.
Compilation of documents. So the PPA and the supplementary agreement
yes.
are there, my lord.
Very well.
I only hope, my lord, it's legible. My lord, Justice Sharma has it, my lord.
No, I don't have it.
Oh,
this is the.
It's not there.
PDF 16.
It's PDF
Compilation.
20. But my lord, lordship may have a look at the hard copy in case, my lord.
Compilation, which page?
Yes, my lord. The PPA, my lord, begins from page 5. And my lord, let me take your lordships, my lord, to first, my lord, the condition precedent, clause 4.1, which is at page 14, my lord.
Yes.
Lord, your lordship has save and accept as expressly provided in Articles 4, 14, 18, and 20, or unless the context otherwise required. The respective rights and obligations of the party under this agreement shall be subject to the satisfaction in full of the condition precedent specified in this clause, the condition precedent by the developer within 240 days from the effective date, unless such completion is effected by any force majeure event, or if any of the activities is specifically waived in writing by CEC, that's myself, my lord.
Well.
The condition precedent for the developer are there, my lord. And my lord, they have to comply with this. Your lordship will find A, obtain all consents, clearance, and permits required for supply of power to CEC as per the terms of this agreement. Then your lordship will see C, achieve financial closure. Then your lordship will see E, obtain power evacuation approval from Karnataka Power Transmission Corporation Limited, as the case may be. And my lord, fulfill the technical requirements, and that's about all, my lord, insofar as 4.2 is concerned. My lord, 4.3 talks of damages for delay by the developer, my lord. Then your lordship may come to, my lord, 5.1, which are the obligations of the developer.
5.1.
5.1. But these are the obligations, my lord, of the developer. Your lordship will find B is comply with all laws and obtain applicable consent, clearances, and permits. So it was their obligation to obtain all permits, my lord. Then, my lord, C, commence supply of power so and so, no later than the scheduled commissioning date. Then, my lord, your lordship will see 5.4, which is at page 19, my lord. Connectivity to the grid. The developer shall be responsible for power evacuation from the power project to the nearest delivery point. The interconnection to the nearest delivery point shall be the voltage level so and so. So it was their responsibility, my lord, to, my lord, for power evacuation to the nearest delivery point, my lord. Then, my lord, page Article 12, then your lordship may come to. Which is at page 30, my lord.
Yes.
So applicable tariff and sharing of CDM benefits, my lord. The developer shall be entitled to receive the tariff at 8.49 12 kVh of energy supplied by it to CEC in accordance with the terms of the agreement during the period between the commercial operation date and the expiry date, my lord. Then your lordship will see the next one, provided further, if as a consequence of delay in commissioning of the project beyond the scheduled commissioning date, subject to Article 4, there is a change in KRC applicable tariff. The change applicable tariff for the project shall be the lower of the following. So, my lord, it will be lower of the following in case there is a delay in the, my lord, scheduled commissioning date. Then your lordship will see the force majeure clause, which is at 36, because this has been applied by the commission against us. Page 36, clause 14.3. Force majeure means any event or circumstance or combination of events stated below which wholly or partly prevents or unavoidably delays or an affected party in the performance of its obligations under this agreement, but only if and to the extent that such events or circumstances are not within the reasonable control, directly or indirectly, of the affected party and could not have been avoided if the affected party had taken reasonable care or complied with prudent utility practice. Then, my lord, it points out which are the, my lord, force majeure events, my lord, act of God, epidemic, etc. Lord, these
which one according to them applies?
My lord, according to me, none applies.
According to them.
No, my lord, the commission actually doesn't put it on a particular clause. What it goes by is the main part of the clause. It just refers to the first part without referring to the subclauses. I will show that from the State Commission's order.
But there must have been some event which they wish to bring under one of these clauses.
What their case was, though there is no pleading, no invocation of force majeure, they had to obtain, my lord, evacuation permission from KPTCL, Karnataka Power Corporation alone. Now, Karnataka Power Corporation gave them a conditional approval subject to, my lord, the construction of 22 kVA line. Now, my lord, there was some delay, my lord, in the commissioning, my lord. Then, my lord, what happened? Some extension was granted, as we said. Thereafter, my lord, they were again not able to comply with because there was delay by taking. Now, this is admitted position, my lord. I am not disputing that, my lord, that 22 kVA line was to be, my lord, complied with by KPTCL. 22 kVA line, 220 kVA line, my lord, was to be complied with. So, my lord, we wrote a letter that since you are not able to comply, we are willing to, my lord, extend the complete scheduled, the scheduled commercial operation date, my lord, subject to reduction of the tariff and you entering into a supplementary agreement. This was our communication. When they received the communication, they said nothing doing, and they filed a petition before the commission. Now look at the prayers, my lord, in the petition, if your lordship don't mind. This is, my lord, page 182, correct? And my lord, the lordship can take it. There is no pleading at all and no invocation of, which is admitted from the appellate order also. Appellate said doesn't matter, we have the power. I will show that, my lord. So, my lord, if your lordship sees page 184, the petitioner submits para 7. That page 184, para 7. It's a very short, my lord, that way, my lord, the petition.
Yes.
The petitioner submits in the letter of KPTCL, petitioner is informed by serial number 7 that evacuation of power and synchronization approvals for the project will be sanctioned approved only after commissioning of 220 kV lines between Birenhalli Thalak and Kuriyur Kauri Biddu. Petitioner submits even though evacuation approval was accorded by KPTCL on a regular basis by letter of 6 February, as per the conditions set out so and so, petitioner will not be able to evacuate power for his proposed 10 megawatt solar power plant. Petitioner submit in this regard, he has submitted a representation. Then, my lord, there are representations mentioned, my lord. Ultimately, my lord, please come to 188. The relief which he seeks on this basis is this, my lord. Whereas it is prayed that the Honorable Commission to please pass suitable orders directing the respondent, 188.
180.
That's the prayer, my lord. Where it is prayed that the commission to please pass suitable orders directing the respondent to execute amended PPA incorporating the following. Extend the completion period for another 6 calendar months from the date of receipt of all approvals from various government agencies, not to impose any penalty, to abide by for the tariffs fixed and all the other terms and conditions as stipulated in the original power purchase agreement entered into between the petitioner and the respondent on so and so, to provide support and assistance to the petitioner in obtaining necessary permission from various government agencies for timely implementation and operation of the power project in accordance with 6.1.3. So there is no reference to force majeure or that the contract was contingent. And now I will show, my lord, the state commission judgment begins from 261 and extra 822. And your lordship will, I'm so sorry, oh, it's another volume. It begins from page 261. The issues framed on page 267.
Yes.
The following issues could arise for our consideration, page 267. In the facts and circumstances of the present case, whether the PPA dated 30th August becomes enforceable by either of the parties in the event of non-commissioning of 220 kV lines between Viranhalli, so-and-so, so-and-so. If the answer to the above issue is in the negative, what direction or order in this regard is required to be issued by the Commission, whether respondent entitled to appropriate the performance security or any portion of it in the present case, whether as a consequence of delay in commissioning the project beyond the scheduled commissioning date, the refixation of tariff as contended by the respondent is legally permissible. What orders? Now, my lord, issues 1 and 2, page 268. Now, let us read this, my lord. What the discussion in the framing. It is not in dispute. KPTCL could not complete the commissioning of 220 kVA transmission line between so and so for reasons beyond its control. The letter dated so and so of KPTCL indicates 220 kV transmission lines would be commissioned soon after completion of work in some locations where right-of-way issues were persisting and after getting approval from the Forest Department. Letter dated so and so, produced along with the rejoinder of the petitioner, indicates that the estimated date of commissioning might be at the end of August 2015. Letter also discloses that more than 50% of the work in this regard has been completed and the balance work is in progress. It cannot be disputed that commissioning of 220 kV lines is an absolute necessity for injecting the power from the project of the petitioner and for evacuating the power by the respondent. Therefore, the contract entered into between the parties is the nature of contingent contract. My lord, there is no such pleading for this. Take it from me, my lord. There is no such pleading. Depending upon the commissioning of 220 kV lines. However, in the PPA, parties have not specified any term regarding the consequence of non-happening of the commissioning of 220 kV lines within a specified timeline. It can therefore be implied that the parties expected the commissioning would take place within a reasonable time. So there is nothing, my lord, in the contract.
You showed us one particular clause in the PPA which says that it is their responsibility to...
Their obligation, my lord. I'll take your lordship back, my lord.
Where was that clause?
Yes.
Show us that clause once.
The obligations of the developer, my lord,
yes,
is, my lord, page 17 of that compilation. I'll have to take
one moment, Mr. Man.
Wanted to see that clause.
That clause?
Clause 5, my lord, are the obligations of the developer.
Yes.
And your lordship will find point 1 talks of obtaining all, B talks of obtaining all applicable consent clearances and permits And my lord, I pointed out 5.4, connectivity to grid
Connectivity to the.
shall be responsible for power evacuation from a power project to the nearest delivery point. The interconnection to the nearest delivery shall be so and so.
And there was one other clause which spoke of the lower of the two tariffs. Which clause was that?
That's Article 12.
Article
12.2. 12.2.
Consequence of a delayed commissioning of the project.
Lord, since your lordships are on the agreement, what I did not point out, my lord, force majeure has, my lord, a clause which says you have to invoke it. If you don't, then that's it. PC page 37 for a minute, my lord.
Yes.
You have to notify the event of force majeure. If your lordship sees page 37, 14.5, notification of force majeure event. The affected party shall give notice to either party of any event of force majeure as soon as reasonably practicable, but not later than 7 days after the date on which the party knew or would reasonably have known the commencement of the event of force majeure. If an event of force majeure results in breakdown of communication rendering and unreasonable to give notice.
No, but where does it fit in, if at all? You specified the events that constitute a force majeure.
From the commission order, it just refers to main part of the force majeure. If your lordship says 14.31, the main part, it just refers to that, doesn't refer to any of the sub-clauses.
Legible, the font is small.
Yeah. From the judgment, my lord, it doesn't refer to any of the clauses. So just stay there, my lord. Come to 14.5, my lord, page 37.
Yes.
Notify the force majeure event, my lord.
Shall give notice to the other.
You see, the proviso is very important. Provided that such notice shall be a precondition to the affected parties' entitlement to claim relief under this agreement. Such notice shall include full particulars of the event of force majeure, its effects on the party claiming relief, and the remedial measures proposed. Affected parties shall give the other party regular reports on the progress. This has not been done. It is nobody says that this has been issued. Come back to, my lord, the commission's order, page 268. I was reading, my lord.
Yes.
No, we finished reading that. But now it's 269. Para D, my lord. The PPA was executed on so and so. It provides condition precedent should be satisfied on or before 240 days from date of execution of PPA, and COD of the project should be so and so. As already noted above, respondent for the first time extended time for fulfilling condition precedent on or before 26 August 30, and for achieving the COD on or so and so on the ground had not yet been commissioned by KPDCL. Subsequently, on the request of the petitioner, as 220 KV line was not ready till then, respondent again extended time for achieving the COD, but without specifying any timing. The commissioning of the project would become impossible unless 220 KV lines are commissioned by KPDCL. If 220 KV lines are not commissioned within reasonable time, contract is to be treated as void for a supervening impossibility, and parties are discharged from performing the contract. What should be reasonable time to wait for completion could be determined better manner by the parties after due deliberation. So, then, my lord, if your lordship comes to 271 now, my lord, because the reasoning will be now, my lord, starting at F, my lord. PPA, page 271 F. PPA does not become enforceable by the respondent if petitioner is able to establish the defense of force majeure events for non-fulfillment of the condition precedent and the delay in commissioning of the project within specified time. The non-commissioning of 220 kVA line by KPTCL is a force majeure event giving rise to an excuse to the petitioner for non-performance of the terms of the agreement. It is found that the respondent has extended time for commissioning the project on the ground that it has not yet commissioned. Said event of force majeure is still continuing. Article 5.73 of the PPA provides, in case of extension due to reasons specified in so and so, and if such force majeure event continues even after a maximum period of 3 months, any of the parties may choose to terminate the agreement. Therefore, the respondent may consider to terminate the PPA under Article 16 of the PPA by taking into consideration the relevant circumstances. For the above reasons, issue 1 is answered in the negative, and issue 2 is answered by holding direction as above be issued to the respondent. That's it, my lord. Now see issue number 3, my lord. So, my lord, force majeure is invoked, no reference to any of the sub clauses, my lord. And my lord, since there was no pleading, I didn't answer that. Then I raised this question before the abject. And your lordship is frank with the questions of law raised. I raised these very questions that you have not invoked. There is no pleading. How could the commission decide it? I raised these very questions, my lord. My lord, if I could state it, my lord, then the issue are the once they come to this conclusion, then obviously, my lord, necessary directions have been issued that the performance security which had invoked has to be refunded 24 crores. So all the necessary consequences. And ultimately, the directions which I issued may also be seen.
You are willing to extend the commercial operations?
Yes, I'm grateful for the question. Subject to, my lord, reduction of tariff, I was wanting to do it, my lord. Please give me, the letter is at page 154. Please have a look at 154. 17th May 2014. Extension of time for scheduled commercial date of operation in respect of your 10 megawatt solar PV project tentatively located at so and so. And at 155.
Yes.
Yes, sir.
150.
Please see 155.
Yes.
Adverting to the subject and as per the request by I'm directed to convey, request for extension of time for scheduled commissioning date can be considered up to 27 September only. As per Article 12.2, since KERC has revised the tariff for solar PV project with effect from 1st April 2013, dated so and so, as rupees 8.40 per kilowatt, the developer is entitled to receive the tariff of so and so discount offered of energy supplied to CEC in accordance with the terms of the agreement during the period between COD and the expiry date. Chief Engineer has issued evacuation approval subject to the condition that evacuation of power and synchronization approval for this project will be sanctioned approved only after commission of 220 kV line between so. Developer shall not hold CEC responsible for loss in generation due to delay in synchronizing the project with KPTCL rate under any settlement. Supplementary agreement has to be executed. Incorporating the above facts shall be got approved. They were not willing to execute this.
Your original tariff was 8 rupees 49 paise.
Yes.
Is it not?
Yes, correct.
Then how do you work out this 2 rupees 39?
What had happened was, my lord, there was a revision in the tariff.
The KERC.
According to that, my lord, we, after discounting, we said that we are proposing this particular tariff because you are wanting extension and this is permitted by Article 12.2.
No, from 8 rupees 49, it will fall to 2 rupees 39.
Yes. Is a discount, my lord.
No, the later order of the ERC fixes it at 8 rupees 40 paise per kWh.
Something wrong.
There's something wrong there. It can't be so drastic of all.
I understand.
No. It's never been done.
Lordship can go back to the Article 12.2 for a minute.
Yes.
That is at page
30.
Yes. For the computation purposes, my lord, page 30 of the documents provided further, if as a consequence of delay in commissioning of the project beyond the scheduled commissioning date, subject to Article 4, there is a change in KPRC applicable tariff. The change applicable tariff for the project shall be lower of the following. Tariff at in clause 12.1 above. ARC applicable tariff as at the commercial operation date, less discount offered and considered in clause 12.1.
So what is that? There's no mention of a discount in 12.1 though.
Lord, the discount was actually offered earlier. It was initially 14. We had given a discount of 6 and that arrived at about 8.49.
Those figures are not correct. The benchmark tariff was 14 rupees 50 paisa, and I gave a discount of 6 rupees 1 paisa, agreed to supply at a rate of 8 rupees 49 paisa. Subsequently, the revised tariff was fixed at 8 rupees 40 paisa, on which they are taking that I will give a discount of 6 rupees 1 paisa, and therefore they arrived at 2 rupees 39 paisa. So it's totally unconscionable. I'll show.
But 14, my lord,
very well, let me complete.
So, my lord, now if you can just go back, my lord, to the impugned order now, my lord. How it deals with this, my lord. The lordship may have a look at page 7 now. The questions frame. How the applicant deals with it. Page 7, my lord.
Now, what does the ERC say finally?
Has confirmed the order passed by the CRC. That's why I was showing here, my lord. I think I didn't show the directions, my lord. 278 are the directions issued by CRC, which are confirmed, commission, which have been confirmed by APTEL. If your lordship has 279,
yes.
The respondent shall restore the performance security furnished by the petitioner by way of time guarantee from the respective dates of their appropriation at its cost. The respondent may consider extending time for fulfillment of the condition precedent and achievement of commercial operation or terminating the PPA dated 30th August 2012 under Article 5.7.30 as he deems fit in the circumstances. So, giving this liberty, the refixation of tariff demanded by the respondent is not valid. Obviously, if I'm not right on the first part, this has to fall. That's the consequence. In the event of the PPA being continued, parties shall hold negotiation to arrive at revised tariff to be paid to the petitioner due to the delay that would occur in achieving the commercial operation of the project, keeping in view the rates for solar energy that might have been discovered in the recent bidding process for solar energy. So now I'm directed to renegotiate. These are the directions. Now let's look at the impugned order at page, my lord, if your lordship can come to page 6 or 7.
When did the KPTCL finally lay these lines?
No.
It's not been done at all?
No.
I believe it wasn't done.
It wasn't done.
Oh.
It was partly commissioned.
Then what remains then?
No, the question is, my lord, I have, my lord, incurred losses because of their non-compliance, because this was not a condition in the agreement. The agreement did not provide that this obligation that you will be
so this of this unit never started there.
I'm sorry?
This unit never started functioning at all.
This was never commissioned.
Never.
No. Because the condition is
so what do you get out of it? The performance bank guarantee.
Lord, yes,
they want
because because I'm impacted. I have a renewable supply of purchase obligation, my lord, and I have lost 48 crores on account of that. That is part of the record. But obviously,
so these orders,
yeah,
these stipulations in the final order,
yeah,
only that first part remains there. With regard to the bank guarantee.
That's it. So that was 24 crores.
Rest of it is all gone.
That rest of it's all gone because, my lord, it was ultimately, they also terminated subsequently, my lord, in 2018.
There was a termination of...
Yes, my lord, 2018 they also terminated it. And, my lord...
so we are only concerned with this performance security.
Yes, my lord, 24 crores we had to, my lord, then refund. Now, please come to page 7 for a minute.
You encashed the bank guarantee?
Yes, but now I have to give it back, my lord, because of the orders passed by the court. Now, please see page 7. Please see para 6, my lord, the questions of law frame, and I will be focusing, my lord, on 2 or 3 of them, which I had framed, my lord. Please have a look at A.
Yes.
Has not the State Commission passed the impugned order without jurisdiction insofar as it is granted relief that was never sought by the respondent number one? Whether the State Commission was justified in holding performance of contract becomes impossible if so and so are not known. When the respondent itself has failed to show its readiness and willingness to execute and complete the project, has not the State Commission misdirected itself in holding non-commissioning of so and so to be an event of force majeure when it was never the case of respondent number one that the project could not be implemented on account of occurrence of force majeure event? This was never the case. And my lord, then my lord, it's about the bank guarantee. G may be similar, small g. Has not the impugned order modified the terms of the concluded contract and is the same not opposed to the diktat of the Supreme Court, which specifically prohibits interference in concluded contracts? Then your lordship may, I also maybe see page 9, hasn't the State Commission misdirected itself passing the bill note which is patently opposed to the terms of the agreement between the parties, which has been approved by the State Commission? Now, my lord, submissions are recorded. Please see, my lord, my submission on this 8B at page 9. The finding of the State Commission that non-completion of page 9, para 8, small b. The finding of the State Commission, non-completion of 220 amounts to an event of force majeure is untenable, as it was never the case of the respondent number one before the State Commission, and it has never issued notice, please note, and it has never issued notice regarding any force majeure event contemplated in Article 14.5 of the PPA. This has been held mandated by the tribunal in case of so and so. Accordingly, said finding of the State Commission as unsustainable without any basis. Based on this finding, State Commission held the question of fulfilling condition precedent by R1 under 4.2 does not arise. The case of the respondent is that contract is void and unenforceable by virtue of so and so. This deals with contingent contract, and the question of taking recourse to any of the provision would not arise. The judgment produced by R1 also support the above contention. The argument raised by R1 are contrary to the pleadings before the State Commission, and this tribunal is liable to be rejected. So I point out both, my lord, the plea, no plea and no invocation. Then your lordship may come to page 18, the observations begin. Right? Page 18, my lord.
Who was required to read that line? KPTCL.
KPTCL.
And you are Chamunda, again state government Karnataka.
I'm not sorry. Yes, my lord. It's
one of your agencies is not doing its job.
Yes.
Has not done its job.
Yes.
And because of that, the power plant was not.
I appreciate that question. Lord, the contract did not make it a condition. It was not the obligation. And my lord, this is a tendered, my lord, the project. The government, I'm a company, my lord. It's not under my control.
Under control of the government of Karnataka.
I'm sorry?
Under the control of the government of Karnataka.
You are both state instrumentalities. Let us see.
I don't dispute. I don't dispute.
But you are not responsible for their failure.
And how Chamunda has suffered a loss?
I'm sorry?
How does Chamunda has suffered a loss?
I had an RPO obligation as well, where I lost 48 crores. It's from other sources, Malo. Renewable energy. No, my lord, I have renewable purchase obligations, my lord, renewable energy. So I have to purchase 48 crores. the discussion, my lord, para 10 at page 18.
Yes. Yes.
Lord, Lord, the first question, 10A, has not the State Commission passed the impugned order without jurisdiction so far as granted relief that were not sought by R1? We observe as well. Then, my lord, what they do is they extract, my lord, from the petition and, my lord, the order which is passed by the Commission. So this is, my lord, both extract. Then, please come to page 20. Paragraph from the above. Your Lordship has page 20 from the above, it is clear. State Commission has dealt on the prayers made by the respondent number 1 on the issues of extension of time for fulfillment of condition precedent, scheduled commercial operation, tariff and performance security. Contention of the appellant that R1 has not raised the issue of force majeure before the State Commission and State Commission has granted relief by holding that non-commissioning of 220 kV lines is a force majeure event is not tenable. We hold that the prayer of R1 before the State Commission was also to pass such other orders as may be deemed fit in the facts and circumstances of the case. We hold the State Commission has power to adjudicate upon disputes between licensee and generating company under 86(1)(f), I show that. And the appellant has also filed a petition under that section of the Act. The State Commission, while adjudication of dispute, is required to go into details of the issues in totality before deciding them. State Commission has had freedom to frame additional issues if required in view of the facts and circumstances of the case and decide upon them accordingly for arriving at a just and equitable decision. In the present case, even if R1 has not invoked the article on force majeure in the PPA or specifically not prayed for any relief under any force majeure event, it was up to the State Commission to go into the details of the issue, provision of PPA and facts of the case to arrive at a decision. In view of the above, here of the considered view, the State Commission has not passed the order without jurisdiction on the issues when reliefs were not sought by the R1. Hence, this issue is decided against the appellant. Clause of force majeure. Lord, your Lordship may come to 26. So, please see page 26. The last paragraph. The State Commission, while dealing with these issues, has gone into the details of the provisions of the PPA and also relied on the letters issued by KPDCL informing the status of the line extension provided by the appellant on the ground of non-availability. State Commission then goes on to hold that PPA cannot be enforceable due to non-commissioning of the 220 kV lines and has termed PPA as a contingent contract. This also is not completed, Manoj. The State Commission has termed the situation as a force majeure while leaving option to the parties about termination. We have gone through the provisions of PPA, communications exchanged between R1 and KPDCL and between R1 and the appellant. We observed that the initial scheduled commercial date of so and so on or before 28th January and the condition precedent were to be fulfilled in 240 days from the execution of PPA. The appellant on the request of respondent number 1 has extended the commercial operation date of solar project till 27 September 14 on the ground of non-commissioning of the said 220 kV lines by KPTCL. However, due to the delay in execution commissioning of the 220 kV lines by KPTCL and the conditional evacuation permission granted by KPTCL while letter of 6 February, the condition precedent as per Article 4.2 of the PPA obtain power evacuation approval from so and so as the case may be cannot be termed as fulfilled. Further, on inquiry by R1, KPTCL intimated said 220 kV evacuation line are likely to be commissioned in August 2020. Further, the appellant was not desirous to extend the commercial operation date of solar project without reducing the tariff and by way of executing another supplementary PPA which has been held untenable and unviable by the State Commission. In such a situation, State Commission has held PPA as a contingent contract, a contract which can be enforceable only upon happening of a certain condition precedent. In the present case, the condition precedent of non-commissioning of 220 kV line has been held as a condition without which PPA cannot be enforced. Further, the non-commissioning of 220 kV lines were beyond the control of KPDCL due to various issues like ROW forest clearance. Hence, as a corollary, it can be concluded that fulfillment of this condition precedent was beyond the control of R1, leading to the conclusion of the State Commission as being a force majeure event, although it was not specifically raised by R1 before the State Commission. Not only not raised, there was no notice also.
Well,
The Council for R1 has relied upon the judgment, which has dealt with contingent contract, and then foot of the page Roman 3. From the above, it becomes clear, under the facts and circumstances of the case on hand, there is no legal infirmity in the decision of the State Commission, terming the non-availability, non-commissioning of the 220 kV line as a force majeure event, and everything is based on force majeure. Then come to page 31, my lord. Page 31 top, small f.
yes.
The issue can be examined from the angle of relief available to the petitioner on account of force majeure events. The defense of force majeure events is available in respect of non-fulfillment of condition precedent and delay in commissioning. Not which clause? There is no reference either by the commission or by the APTEL, my lord. Which sub-clause? And the delay in commissioning of the project within the specified time. Petitioner has contended both these events could not be achieved as KPDCL had not yet commissioned the so-and-so. We are of the opinion, non-commissioning of 220 by KPDCL is a force majeure event, giving the rise to an excuse to the petitioner for the above-mentioned non-performance. Force majeure is defined as any event or circumstance or combination of events which wholly or partly prevent or unavoidably delays any effective party in the performance of his obligation under the agreement, subject to certain exceptions. Admittedly, the case of the petitioner does not fall under any of the exceptions mentioned in the said article. Therefore, issue 3 is answered in the negative.
What was issue 3?
Yeah, issue 3, my lord, we can go back. Page 7. My lord, if your lordship sees C, this one. Has not the State Commission misdirected itself in holding non-commissioning of 220 kV lines that KPDCL?
So it's answered in their favor. The question is framed in the negative.
It's answered in their favor. But then we go on to the bank guarantee, etc. Obviously, my lord, if these issues are answered against me, the consequence and relief has to be in their favor, my lord.
The direction of the tribunal, the ERC was that you would release the performance bank guarantee.
Yes. So, my lord, I had appropriated, so I refunded the money.
That's all?
My lord, do I need to show case law, my lord? Court cannot make out a case not pleaded by the parties, my lord.
One judgment to give us.
Yeah, I can give a lot. And what I do is I won't read it, I'll just give the citation because it's so certain law. My lord, I believe there's one judgment of your lordships also in this, my lord. 2024, 4 SCC 230. It's under the Consumer Protection Act, my lord. And your lordship's judgment, my lord, Venkatrama Krishnamurthy versus Lodha Crown Milkmart Private Limited.
Which paragraph?
Paras 19 to 22, my lord.
Very good.
Then, my lord, I'll give this, I'll just hand over, my lord. As I said, I'm not going to read this, the proposition. Then, my lord, please give. Now, the other judgment which I want, a citation, I'll give to your lordship, my lord. Give it to me. My lord, 2002, volume 5, SCC 337, which follows, my lord, 1953 Supreme Court, 2002, volume 5 Supreme Court cases, 337, para 43, follows, my lord, 53 Supreme Court, Trojan and Company, where, my lord, the extract is one line. It is well settled, decision of a case cannot be based on grounds outside the pleadings of the party, and it is the case pleaded that has to be found. And, my lord, the third citation is Ramsaru Gupta, 1987, 2 SCC 555. And I'll give the paragraphs, my lord. And your lordship may also make a note, my lord, there was no invocation. The proviso requires condition precedent. That notice has to be given. That also was not given, my lord.
Yes.
Paras 6 and 7 of answer, my lord, 87 to SEC.
Paras 6
and 7.
Yes.
And then 2. Yeah.
Yes.
Please. But I do not have the additional compilation filed by my learned friend, but
you don't have
SLP, my lord, with the SLP that they have filed the
you don't have this compilation.
I do not have that, but that is I can refer to in the SLP. The same ones are produced. Relevant extracts were produced in the SLP, my lord, so I will take my lord through that. Lord.
Yes.
Setting up of evacuation lines, my lord, is the condition precedent.
Where do you get this?
My lord, you kindly see 4.1. I don't know because page 92.
4.1.
4.1. The last one.
Your Mr.
Conditions precedent.
Your name?
My lord, C. Mohan Rao.
E?
Mohan Rao.
Mohan.
Page 61 of the 92. Sorry, 92 of the paper.
Clause 4.1.
4.1. Article 4 is starting with condition precedent, my lord.
Yes.
4.1 condition precedent, save it except as expressly provided in Articles 4, 14, 19 and 20, and or unless the context otherwise requires, the respective rights and obligations of the parties under this agreement shall be subject to the satisfaction in full of the conditions precedent specified in this clause 4. The conditions precedent by developer within 240 days from the effective date, unless such completion is affected by any force majeure event or if any of the activities is specifically waived in writing by the CESC in Mysore. Then, my lord, 4.2, what are the conditions precedent for the developer?
Yes.
My lord, the rest of there are two sorts of conditions which are exclusively within my hands and certain which are not in my hands, like that is E. We are concerned with E, my lord. Obtained power evacuation approval from Karnataka Power Transmission Corporation Limited, CESC Mysore, as the case may be. So I have to obtain as a condition precedent for setting up an approval from the Karnataka Power Transmission Corporation. My lord, then my lord may kindly see 4.2.1, 94 page, my lord.
Yes.
What? 4.2.1. Developer shall make all reasonable endeavors to satisfy the conditions precedent within the time stipulated. So, if it is not in my hand, only I can make the best of the endeavors.
There's a time stipulation though.
No time stipulation though, but
240 days is the time stipulation.
240 days, because if it is provided, but it is a condition precedent that there has to be evacuation lines have to be there. Then, my lord,
no, here it does not. It does not speak of the lines.
No, it is.
It speaks of your obtaining the power evacuation approval from the KPTCL.
Correct.
Not that it speaks of laying of lines by the KPTCL.
No, no. It is saying that I shall make all reasonable endeavors and obtain approval.
Approvals, yes.
Then there is another one, my lord. CESC Mysore, that is the petitioner, shall provide to the developer all reasonable cooperation.
Where are you reading?
My lord, 4.21 only in the same. This is in two parts. First,
all the reasonable cooperation.
All reasonable cooperation shall be provided. Reasonable cooperation as may be required to the developer.
What cooperation can they give you?
My lord,
in this regard,
in pursuing the transmission corporation.
For what?
To obtaining of the lines.
To obtain the approval. Laying of the lines is not mentioned anywhere here.
I'll come to that, my lord. So, in obtaining the approval. So, there are, in this, my lord, unlike the previous other conditions that my learned friend read, which are exclusively within my domain, as far as conditions precedent.
Once you undertook that you would satisfy these conditions precedent within 240 days, that responsibility rests with you.
My lord, in my humble submission, my lord, I'll come and show. that I have made all the endeavors. That is the reason. Initially, I kept on approaching them. When these transmission lines...
You may have made all reasonable endeavors. There's no doubting that.
So,
but once the lines are not laid at all, that is something that you always have taken into consideration when you entered into this PPA.
My lord, I was being told that there is some delay due to certain aspects and there is some forest permissions ought to be given, more in time was sought. Initially I came, they cooperated and extended the time. The second time I went to them saying I want a further extension of the time. My lord, then they wrote this letter, my lord, may I take my lords to...
No, but leave that aspect. Now you come to the force measure.
My lord, I'll come to that, my lord.
That is the main thing now.
I'll come to that, my lord. But may I take my lord first to this?
Which one?
My lord, this is...
The letter?
Yes.
Page 154.
This is the letter that is starting at 162, my lord.
162?
Yes.
What is that letter?
This is the letter addressed by the petitioner.
By you?
No, the petitioner. In response to my letter requesting for extension of time.
Page 162. 3rd June.
Starting at 162.
162. This was after their letter dated 17th May.
Yes.
Again, you wrote to them.
17th May also, my lord, I'll read that.
17th May is their letter.
17th May is also their letter. This is also their letter.
Why would there be two letters? There was an intervening letter from you in between.
Yes, intervening letter seeking again extension of...
Where is that letter?
My lord, that letter is not there.
What is the meaning?
Okay, next. But my lord, it is clear from the narration that they have referred to these letters.
What did you ask for in that letter?
Extension of time.
Further extension of time.
Yes.
And also modification of what they had suggested?
No, they have not. What they have done is in 17.5, my lord, they have said two conditions. They said, we will grant extension subject to your agreeing to supply power at 2 rupees 39 paisa and that you will not take any ground even if there is no lines are set up. Well, that's what I am going to read. They have reiterated this. I am not reading that because whatever has been stated in that 7.5 letter was reiterated in this and they have given the additional grounds also. That is the reason I am reading this. Starting from 166, my lord. Your request for extension of time for scheduled commissioning date can be considered up to 27/9/2014 only as per provisions of Article 8.5 of the PPA. The developer shall commission the project within 17 months from the effective date by considering the date of execution of supplementary agreement on 28/5/2013 as the effective date as part of cooperation. So they are saying as a cooperation that we are willing to extend the time till another till 27/9/2014.
Yes.
My lord, then may I come, my lord, that the conditions that they are imposing, that is Roman small 2, tariff clause. I'll read, my lord. You are very, very well aware of the terms of PPA while signing. Your attention is drawn to Article 12.2 of the PPA. As per Article 12.2 PPA, if there is a delay in commissioning of the project beyond the scheduled commission date, subject to Article 4, if there is a change in KERC applicable tariff, the changed applicable tariff for the project shall be lower of the following. Tariff in clause 12. KERC applicable tariff as on commercial date operation, less discount offered and considered in the clause 12 of the above. Since KERC has revised the tariff for solar PV projects with effect from 1/4/2013 by the order dated 10/10/2013 as rupees 840 per kilowatt hour, the developer will be entitled to receive the tariff of rupees 2 rupees 39 paisa per kilowatt hour of energy supplied by CEST Mysore in accordance with the terms of the agreement during the period of COD and expiry date. The chief engineer, Bangalore, the KPTCL, has issued evacuation approval subject to the condition evacuation of power and synchronization.
What is the date of this letter?
My lord, they are quoting it, my lord. It is the date is not given in this, but it was.
This letter must have been obtained by you.
Yes, my lord, but
you don't know the date of the letter.
It is not there in the. I tried to look for it and I can't find it. I'll see again. if I can find it. But it is before my writing a letter to them. I referring to this letter I addressed before 17.5.
But the date of this letter becomes crucial.
Before 17.5, my lord. I'll try and get it.
You'll have to give us the exact.
I'll give that date, my lord. that is prior to 17.5. That pursuant to this only, I addressed a letter to them saying that this is what I have received from the KPTCL and asking for
6th February 2014, page 134 is the document.
6th February
2014, page 134.
Page 134.
Please. Is 6-2. That is prior to 17, immediately a week before that, 2 weeks before that.
Now, in any event,
My lord.
none of this came to pass. So the question of the tariff is not relevant at all.
No,
Because
the
you
issue
never
is-
commissioned your project.
No.
You never commissioned your project. So
I could
all
not
that
have-
is over now.
My lord, I could not have commissioned.
Whatever it is over now.
It is over now. The only issue.
Only issue that survives is whether you are entitled to say that your performance bank guarantee ought not to be encashed. That is the only issue
Yes,
left.
issue is they are saying that.
Now, for that, for you to say that my performance bank guarantee ought not to be encashed by the other side, you will have to bank upon this force measure clause if at all you want to. And then you will have to tell us how it even applies and whether it would apply even if applicable when you never even invoked it. Those are the two issues that you need to
My
answer.
lord, this is for the reason, my lord. I went to the.
You specified what are the force measure events in your contract. It is not
Correct.
for the ERC or the APTEL
Correct.
to apply some dictionary meaning and say that notwithstanding what they said are force measure events, we will come up with a general definition of force measure event and bring in a new event and apply it even though you never raised it. You never raised it, you never invoked it. So in spite of all that, is it open to these two bodies to apply it in your favor and give you this order? That is what you need to answer.
There are two reasons that I will be giving, my lord. First of all, that how and why I did approach the commission, state commission bodies. My lord, this is because I sought an extension. The KPTCL wrote a letter saying that approval will be granted only after commissioning of the 220 kV lines. This one. So I said that, and please extend the time because this is, they will grant approval.
Unfortunately for you, you also understood that this was not a force measure event. That is why your application at petition at 182
my lord, it is
doesn't even mention.
My lord, in
force
my
measure.
humble submission, my lord, it is a force measure event, but the words
You specified what the force measure. This is a contract between the two of you. You specified what constitutes a force
My lord,
measure
I take
event.
my lords through two letters of the petitioner.
There is no question of rewriting the contract between
I'm not
the
asking.
two of you.
No, they are rewriting.
Where is the force measure event? We have to come back to that.
It is not me who is rewriting.
Show us where this fits
My
in
lord,
to your force measure clause.
May I just take two more letters, my lord, with my humble submission?
We are not concerned with the tariff. We are
Because,
not
my lord,
concerned with what they were willing to offer you, what you agreed upon. That also, that clause 5.2, is it? Clause 5.2, you yourself agreed to that discount being applied in the event of your delay in commissioning the
my lord,
project.
in 5.2 is not with regard to condition precedent. Condition precedent is the
Not
one
that.
that I read.
Once you in your own wisdom
My lord,
thought it appropriate to apply this tariff,
my lord, today,
this
as on
tariff
today,
rate,
my lord, as on today, whatever has happened before the tribunal lower courts is gone. Now, all that is there is only as regards whether the petitioner is entitled for damages. The complexion of the case is entirely changed. My lord, what has happened, unfortunately, with
once
this case
you
was-
fail to commission, once you fail to supply,
May I take 10
they're entitled to invoke the bank guarantee. That is their case. You'll have to tell us how
I'll
they
come
are
to that.
not entitled to invoke the
I'll
bank.
come to that, my lord. But
Yes.
before that, may I take just 10 minutes to
On
how
what
and
issue?
how this came. May I just take my lords to this letter that I was reading. I just at 167. My lord, may see who is changing the terms of the contract. They are saying there is a delay on part of the KPTCL in setting up of the power lines.
Yes.
Therefore, this is what 167.
Yes.
That Chief Engineer KPTCL has addressed a letter stating that, my lord, this is a quote that they have quoted. May I just read, my lord? 167.
Yes.
166. Third line. This is a letter, they are referring to the letter of the Chief Engineer KPTCL. Evacuation of power and synchronization approvals for this project will be sanctioned/approved only after commissioning of 220 kV lines between Berennahalli and Hiriyur. This is the quote. So they said that we will be able to do it only if there is commissioning of this. The developer shall not hold CESE Mysore responsible for loss in generation due to delay in synchronization of the project with KPTCL grid under any circumstances. Well, this in my humble submission is not the PPA. How can they saying that now, because of fault on part of the KPTCL, you should incorporate a new fresh supplementary agreement incorporating this clause that I shall not hold the petitioner responsible for loss of generation. I am not seeking amendment. They can stand or fall on the basis of the PPA. What today they asked me by this letter. This is what is the letter I am aggrieved of, and subsequently I went to the commission. What they are saying is there is a delay on part of the KPTCL. Therefore, we are extending, agreeable to extend time till 14/5, subject to the condition that you will agree for 2 rupees 39 paisa, 1, and 2, that you shall not hold the petitioner responsible. Well, whatever the obligations will fall under the PPA.
Very well.
Now they are asking no. We will rewrite and asking us to execute a fresh supplementary agreement. May I just read, madam? Mysore, the grid under any circumstances. However, CESE Mysore will arrange.
We'll continue after.
Still.
I mentioned item 25, Lordship, the council is unwell. We have
no adjournment mentions. Please wait till the matter reaches. If it reaches, then you can ask.
May please. I understand Mr. Sibal was in some difficulty, I think it made
But we said we'll assemble at 2 and then whatever needs to be done, we'll tell us.
Yes, I leave it to your lordship. Otherwise, my lords, I'll.
No. We are not saying that we will not adjourn for Mr. Sibal. Should Mr. Sibal,
Thursday?
when do you?
Thursday.
We'll accommodate Mr. Sibal. There's no difference.
I leave it to your lordship, but otherwise I'll carry it on.
No, you're always welcome, sir.
Okay. But Mr. Sibal is on his legs, that's all.
You're always welcome.
Lordship.
Even after Mr. Sibal finishes, concludes your wish to add, there's no difficulty.
Your
We will
lordship.
definitely accommodate Mr. Sibal. There's no doubt. There's no doubt in our mind.
Hello?
1 minute, ma'am. Just 1 minute. One difficulty which we have seen with another senior counsel is this, that twice we have, 2-3 times we have accommodated him. And we understand he is very, very in demand in other courts. Today also we had to adjourn. The only thing is that next date he should be there. That's about all.
Lordship may have it on Thursday or next Wednesday.
Not Thursday.
So miscellaneous.
Wednesday.
Lord's Thursday is a miscellaneous day.
Next Wednesday.
My lords.
What is it that you wish to say? Okay.
My lords, could we just have one small request, which is that they have 3 eminent counsel. It's at the stage of rejoinder. Of course, Mr. Sibal must be accommodated and he's in if he's on his legs. But my lords, perhaps my lords may consider that given that there have been 11 adjournments.
May I just only say one thing?
Yes.
On the last day, Mr. Patwalia got up to say some date. And I responded to Mr. Patwalia by saying that we are not a vending machine. You insert a coin and judgment will come in. When I went back, let me share this with you. And Mr. Patwalia is here. I must apologize to him.
No, not at all.
No, 1 minute.
These things happen in court often.
1 minute. When I went home, let me tell you, all my law clubs and interns are sitting here. And they told me that perhaps, sir, you were unduly harsh to Mr.
They do not know, my lord, for how long.
1 minute. No, I am. You know me.
You should have told them, my lord, that when your lordship was in Shimla and Chandigarh, since then.
You know me. I admit my mistake. I apologize.
No, there is nothing. I have forgotten about it. No, don't remember.
Ma'am, only thing is, what is the tearing urgency?
I understand.
That's it. Simple. After all, they are asking for 1 week only. We know that there are 3 counsels. We also know that Mr. Devan is finished. We have been accommodating each one of you day in and day out. There's no difference.
Absolutely, my lords. There's no doubt about that.
Please.
Wednesday.
Wednesday. No.
Wednesday means tomorrow.
Next Wednesday.
Obviously not. Not 20th.
20th.
See, there is 1% chance of this 20th may not be convenient for me personally. 1% chance, but I'm not sure. If I'm, then we'll move on the premise that we'll keep it for 20th. But if I'm not there, then you'll have to accommodate me.
Goes without saying.
All right.
And then it'll go to next 8 months of time. नहीं फिर 26 को करेंगे 26
Yes,
26
Tuesday. That's good. 26th.
Yeah.
Then your lordship may keep it only on 26th. Then to begin with only. Then why do that?
Or would 25th also suit? I think 25th.
26th. 25th is also all right. End of the board.
Monday.
End of the
board we can do. Yes.
Which way? 20th.
25th.
25th Monday.
So,
26th.
26th.
What we'll do is then, Mr. Patwalia,
26th is okay, man.
26th we'll keep it in the morning.
So grateful.
Let's keep it in the morning.
Yes.
All.
Please inform Mr. Sipal. 26th morning, we'll keep it top of the board.
All. Great.
List on 26th, top of the board.
My lords, may I? My lords, may I? My lords, some very new arguments have been made that are not before the courts below. So we will just take a very brief time to address my lords after they are done.
No problem.
So great.
We have told you that's so great. Till the time everyone says thank you very much, we will not.
We are so grateful.
So 26th, immediately after the fresh matters, hail and other matters, TP matters, we'll take it.
As well.
Thank you.